Welcome back. My name is Dr. Kamal Singh, Assistant Professor in the Mewar University, Gangarar, Chittorgarh. I teach you again Contract Act 1872. Capacity to contract. Topic name Cap- Capacity to contract. Understanding the legal framework. Introduction. Definition of contract. A legally enforceable agreement between two or more parties. Importance of capacity to contract. Ensures parties are legally capable of entering into binding agreements. Legal framework governed by the contract law principles. Refer to Section 11 of the Contract Act 1872. Essential of capacity to contract. Majority. First of all, first majority must have attained the age of majority as per law, 18 years in most jurisdictions. Sound mind. And the next, sound mind must understand the contract and its consequences. Not qualified by the law includes insolvency, criminal status, etc. Minors capacity to contract. General rules. Contracts with minors are void. General principles. Contracts with minor are void. Exceptions. Contracts for necessity. Beneficial contracts. Case law. Leading case law. This topic is Mohri Bibi versus Dharmodas Ghosh. Unsound mind. Categories of unsound mind: idiot, lunatics, or intoxicated persons. Persons temporarily incapable due to mental illness or intoxication. Legal principle: contract are void if entered during period of incapacity. Persons disqualified by the law. Examples: insolvent individuals, foreign sovereign without proper permissions, corporations acting beyond their authority. Case studies. Case number 1. Minors contract declared void. Minors contract declared void. Case number 2. Persons under intoxication claiming incapacity. Discuss judgment and outcomes. Consent and free consent. Next topic: consent and free consent. Legal principles in contract law. Introduction. Definition of consent. Consent means an agreement between parties upon the same thing in the same sense under Section 13 Indian Contract Act 1872. Importance. Consent is essential for forming a valid contract. Free consent. Consent must not be influenced by external factors like coercion or fraud. What is free consent? Defined under Section 14 of the Indian Contract Act 1872. Consent is free when it is not caused by coercion, undue influence, fraud, misrepresentation. Coercion. What is coercion? Definition: committing or threatening to commit an act forbidden by law to obtain consent under Section 15 Indian Contract Act 1872. Examples: forcing someone to sign a contract at gunpoint. Effect: contract is voidable. This is contract voidable. Legal effect: this is contract is a voidable. Undue influence under Section 16 Indian Contract Act 1872. What is undue influence? Definition: when one party uses their dominant position to obtain unfair advantage. Example: a doctor forcing a patient to sell property. Effect: contract is voidable. Legality of the contract: contract is voidable under Section 16. Fraud. Definition: intentional deceit to induce a party to enter a contract under Section 17. What is fraud? Under Section 17 Indian Contract Act 1872. Definition: intentional deceit to induce a party to enter a contract. Elements: first, false representation. Second, knowledge of falsity. And next, intention to deceive. And effect: validity of this contract is voidable under Section 17 Indian Contract Act 1872. Next, Section 18. What is representation? Definition: false statement made innocently without intent to deceive. Under Section 18 define misrepresentation. Example: incorrect information about a product's quality. This contract is a voidable. Such type of a contract is a voidable. Misrepresentation. Definition: false statement made innocently without intent to deceive under Section 18 Indian Contract Act 1872. And the next, mistake. Type of mistake: mistake of fact, misunderstanding essential facts of the contract. Mistake of law, misunderstanding legal principle. Effect: mistake of fact, valid. Mistake of fact, void contract. Mistake of law, generally enforceable. What is legality of mistake in the contract? Such contract is a void and voidable and legal. Void agreement, legal framework and key concepts. Introduction. Definition: agreement non-enforceable by law. Legal basis: Section 2 Clause G of the Indian Contract Act 1872 or equivalent provisions in their jurisdiction. Importance: Differentiating between enforceable contract and void agreement is crucial to avoid legal dispute. Avoid legal dispute. Characteristic of void agreement. Non-enforceable characteristic of void agreement. What is void agreement? Such agreement is a void agreement, non not enforceable by the law. First condition. And second condition, like person or more essential element of a valid contract. And second, third, no legal rights or obligations created. And fourth, void from inception, ab initio. Void contract is a ab initio. Ab initio means from the beginning. Example of void agreement. Agreement made by incompetent parties. Void made by incompetent parties like minors, unsound mind. Agreement without consideration. And next, agreement with unlawful objects. Agreements in restraint of trade, marriage, or legal proceedings. Agreement involving uncertainty, wagering agreement. This agreement is a void agreement. Example of a void agreements. Agreements made by incompetent parties, agreement without consideration, agreement without unlawful objects, agreement is a restraint of trade, marriage, or legal proceedings, agreement involving uncertainty, wagering contract. Agreement declared void under the Indian Contract Act, Section 23, unlawful object or consideration. And next, Section 25, agreement without consideration with exceptions. And next, Section 26, restraint of marriage. And next, Section 27, restraint of trade. And next, Section 28, restraint of legal proceedings. And next, Section 30, wagering agreement. Such contract is void under Indian Contract Act 1872. Such agreement declared void under the Indian Contract Act 1872. And again repeat, section 23, section 25, section 26, section 27, and section 28, and section 30, and more sections in the Indian Contract Act 1872. And next topic, quasi contract. Understanding implied obligations in law. Introduction. Definition. Quasi contract are obligations imposed by law to prevent unjust enrichment. And again repeat, definition. Quasi contract are obligations imposed by the law to prevent unjust enrichment. Quasi contract, unjust enrichment, a legal basis recognized under section 68 to 72 of the Indian Contract Act 1872. Legal provisions under sections 68 to 72 of the Indian Contract Act 1872. First, nature. Second, not a real contract. And third, no prior agreement between parties. Type of quasi-contract. Indian Contract Act. First, Section 68 claim for necessary supply to a person incapable of contract. And second, Section 69 reimbursement of a person paying money on behalf of another. And Section 70 obligations of a person enjoying the benefit of a non-gratuitous act. Section 71 responsibility of a finder of goods. And Section 72 liabilities for money paid or receiving by mistake under caution. And next topic, remedies for breach of contract, legal framework and applications. Introduction. Definition of breach of contract: failure to perform a contractual obligation. Under section 74, 73, and 74 and 75 Indian Contract Act 1872. Introduction. Definition of breach of contract: failure to perform a contractual obligation. Importance of remedies: to protect the right of the aggrieved parties and ensure justice. Legal framework based on principle of contractual law, like Indian Contract Act 1872. Type of breach of contract. Actual breach occurs when a party fails to perform their obligations on the due date or during performance. Anticipatory breach occurs when a party declares in advance their intention not to fulfill the contract. Remedies available for the breach of contract: first, damages; second, specific performance; third, injunctions; and fourth, quantum merit. Thank you.